Good evening. I'd like to call this meeting to order, that this Committee of Adjustment meeting held on August 26, 2020, come to order at 7 p.m. May I have a mover and a seconder, please? Moved by Patty Kennedy, seconded by Rick Webster. All in favor? Carried. Are there any disclosure of pecuniary interest this evening? We have two. Let them be shown. Go ahead.
I have a declaration of interest in pecuniary concerns with regards to application B03-20, agenda item 4.8, sorry.
That was Lauren Cooney. Member Kennedy, are you declaring one?
I am declaring a direct pecuniary interest in consent application B0320 on the basis that my home is within the notice area for the application.
Thank you. Can I have a mover and a seconder that the Committee of Adjustment minutes held March the 11th, 2020 be adopted as presented? Moved by Lauren Cooney, seconded by Henry Vanderweel. All in favor? Carried. I'd like to welcome you to this Committee of Adjustment meeting to allow the public an opportunity to express their views in regards to proposed minor variances and consents within Springwater. Each applicant and their agent, if applicable, will be given the opportunity to present the applications to the committee and public. Additional information on each of the applications, including any presentation materials, is available in the committee agenda on the township website. All oral submissions will be included in this meeting's minutes and form part of the public record, including the name and address of the speaker, as information collected under the Municipal Freedom of Information and Protection of Privacy Act. The minutes of this meeting will be posted on the township website. All comments or questions should be addressed through the chair. I'll now ask the Secretary Treasurer to please introduce the first application, item 4.1.
Thank you, Mr. Chair. Minor variance application A01-20 by R. Mitchell, owner of land municipally known as 1316 Highway 26. The purpose and effect of the application is to fulfill a condition of consent, application B0619, to permit the continuation of the existing detached accessory building located on the severed lands prior to establishment of the main residential use.
Thank you. Have any additional correspondence or comments been received?
We have received comments from the chief building official dated August 14th stating no objection. The setback indicated would not create a concern from a building services perspective.
Thank you. Can I please have the applicant or their agent introduce themselves and present the application?
Hello, I didn't know we had to say anything. It's Robert Mitchell speaking.
Go ahead, Mr. Mitchell.
I'm not sure what to say. I thought the application was just written down, and I'm not sure what to say, to tell you the truth.
Perhaps you could just quickly, for the benefit of everyone, tell us what your application is and it is about. We understand what it is because we have the documents here, but those who are watching may not.
Okay, well then, as you're aware, we're in the process of attempting to subdivide this lot behind us here, and that building has been sitting on it for eons, and so we just want to keep that building there, even though we don't have a building permit for the lot yet. That's the best understanding or explanation I can give you right now, I guess.
Okay, thank you. So what I'm hearing is that you wish to retain a building that is on a parcel of property, and that there is no building permit for a future residence on that property as yet, as is required. Is that correct?
That's correct.
Thank you. Are there any members of the public registered to make an oral submission relating to this proposal? Hearing none?
Yeah. There's none, no oral submissions for this proposal, correct, right? Yes, no oral submissions.
Thank you. Does anyone from the committee wish to comment or have questions on the application? I see none. Madam Secretary, do I have a motion? Or where do I find a motion tonight?
I guess you should read these.
May I have a mover and a seconder? Moved by Lauren Cooney, second by Henry Vanderwielen. I'm assuming we're taking adoption of this. That the Committee of Adjustment, having given consideration to the applicable provisions of Section 45 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the land in question and its surroundings, as addressed in the planning report on the application dated August 26, 2020, the correspondence received and information presented at the hearing held on August 26, 2020, and the discussion on the matter hereby approve application A01/20 as applied for. All in favor? Unanimous, carried. Thank you. The secretary is ready. I'll ask her to introduce item 4.2.
Minor variance application A0420 by D. Haman, owners of land municipally known as 1933 Vesper Valley Road. The purpose and effect of the application is to permit the construction of a 260.12 square meter and 6.4 meter high detached accessory building, which will exceed the maximum floor area and height permitted for detached accessory buildings on the subject property.
Thank you. Has there been any additional correspondence or comments received?
Yes, we have received comments from the Ministry of Transportation dated March 13th, 2020, stating no concerns. We've received comments from the chief building official dated August 25th, stating no objection based on the fact that the building will be utilized for residential purposes only.
Thank you. May I please have the applicant or their agent introduce themselves and present their application, please?
Hi, this is Dan Haman. Yes, I'm applying for permission to construct a storage facility for my equipment that's slightly oversized what's allowed and over height.
Thank you. Are there any members of the public registered to make any oral submission regarding this proposal?
Thank you, Chair. There are no members of the public which are registered to make an oral submission.
Thank you. Does anyone from the committee have any comments or questions of the applicant?
I have one for staff, through you, Chair. With respect to the chief building official's comments there, I just want to clarify that the proposed building is for storage and not for residential purposes. Is that just a simple typo in the chief building official's comments? Over.
Through you, Mr. Chair, to Member Cooney. The application is for a residential detached building to be used for residential purposes only. I believe when the applicant mentioned equipment, he meant, or he could speak more to that if there's more questions about the proposed equipment storage, but it is for residential purposes only. Thank you.
Okay, thank you.
Thank you. Mr. Haman, could you please confirm what your equipment is?
Yes, it's for, I have a fifth wheel RV, lawn care equipment, some classic cars, and a skid steer. But it's all personal, my own stuff.
Thank you. Is there any other questions from any of the committee members? I have an application here. Does anybody wish to move and second it? Moved by Patty Kennedy, second by Lauren Cooney. And I assume it's for acceptance. That the Committee of Adjustment, having given consideration to the applicable provisions of Section 45 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the land in question and its surroundings as addressed in the planning report on the application dated August 26, 2020, the correspondence received and information presented at the hearing held on August 26, 2020, and the discussions on the matter hereby approve application A04/20 as applied for. All in favor? Carried unanimously. When the secretary is ready.
Thank you. Minor variance application A05-20 by L and J Hendry, owner of lands known municipally as 74 Victoria Wood Avenue. The purpose and effect of the application is to permit the construction of a deck and a detached accessory building on the subject property, which will result in overage in lot coverage. A maximum lot coverage of 38.35% is proposed, whereas the zoning bylaw permits a maximum of 35%.
Thank you. Do we have any additional correspondence or comments?
We have received comments from the MTO dated March 13th stating no concerns or comments, and the chief building official dated August 14th stating that impact on LID features will be minimal based on the coverage calculation and depth and location of below-grade construction. No objection to application.
Thank you. May I please have the agent, or the applicant or its agent, introduce themselves and present the application.
Good evening, committee. Luke Hendry from the application. Essentially, we built a deck. It was pre-built. I made a call in late last year, and I was told I did not need a deck for a detached deck. So we built the deck and a shed. The shed's actually less than what we had provisioned for. It's only 56 square feet instead of 108. But I guess that's my application, and hoping to hear what your thoughts are.
Thank you. Any members of the committee have any questions? Mr. Webster.
Thank you, Chair Gannon. I'm curious, and I did ask this question, I had it printed out, but it disappeared in my package. This is a floating deck? It's not attached to the house?
Yes, it is, sir.
Did I hear yes?
Yes, you did. It's a floating deck, not attached to the home.
Okay, and how did you become aware that the deck was oversized?
We had a permit inspector come by the house middle of February 2019 and asked if we could present a permit. At that point, we went through the permit process because we did not have a permit at that time based on the initial conversation from the previous year. So we started to go through the permit process. It is currently with the building permit team, and then that's where it kind of came to that next level over to the minor variance committee.
I'll just continue, and I can go through the chair, but sometimes it's easier to just talk you directly instead of going through our chair. But what was the permit inspector? What was his purpose of his visit? Do you know?
I believe they were trying to close our subdivision, our area of the subdivision. It's a brand new subdivision. I believe that's why he came to look at it, and then he noticed that we had a floating deck. That's all I know. I can't speak for him, unfortunately.
Go ahead, Secretary.
Through you, the chair, to Member Webster. I believe what happened was that as the building was completing other inspections such as final or occupancy in the subdivision, they noted that the deck was there and that there may have not been a permit, so they approached the homeowner and from there realized that a permit would have been required and issued in order to comply. When they've submitted their building permit, planning reviewed it and noted that they were over in lot coverage based on the structures on the lot. So they were advised to apply for a minor variance through that process.
Perhaps, Mr. Webster, I can assist you. The floating deck is still considered a structure under the building code, it exceeds 104 square feet, therefore would require a building permit, even though it isn't affixed and attached to the premises. And the way I am understanding this is that that floating deck combined with this small outbuilding exceeds the maximum lot coverage permitted of 35% by 3.8%. So while the applicant may have gotten or applied for a building permit, it was after I'm going to clarify that, it was after the deck was already built. And at that point, they determined that he was over the allowable maximum coverage. Regardless of whether he had a deck or 5, 6 sheds that were all under 104 square feet, if they passed the maximum 35% of lot coverage throughout the premises, he would still need a minor variance or remove one of these sheds or
I
whatever.
don't know what it was called, but I believe Lauren spoke to it correctly.
Yeah, so I
I
believe
could
it was
assu-
the final inspection that they would have been completing. So after occupancy, there's a final inspection just to confirm all building code requirements have been met and to release the permit essentially.
I don't know that there's any inspections past occupancy inspection, but perhaps a grading inspection to make sure that, the grading is, the final grades are in place, but you can't have an occupancy. You have to have railings, you have to have running water, et cetera. A final building inspection, I guess what I'm saying here is that if a building inspector is creeping around houses looking for decks that aren't built yet, I didn't think that was a policy of the municipality. I thought that we would attend on the basis that somebody complained. I'm also wondering if he was given, if the applicant was given an option, since it's a floating deck, to reduce the size, because the deck to the east does comply, and it's maybe 10 feet narrower than the one that's at 74 Victoria. I was wondering if he was given an option. In addition to the stated size of exceeding 35%, that includes his application for a 10 by 10 shed, which is 100 square feet. That shed did not exist there in February. So, and then I'm also concerned that he said that somebody contacted the municipality and asked him if he needed a permit and was told no. Anybody have any?
If I can just interject, Mr. Webster, the Township of Springwater does request a final occupancy to determine, an occupancy permit ensures that the minimum standards are completed, but not the whole house is completed. So there is a final inspection that is done, and it's generally at the request of the property owner to ensure that in some cases there's a deposit being held for work, et cetera, and that's how it is released. So, I can't speak on this particular case, how the building inspector got there, but after an occupancy inspection, there is a final inspection to ensure that everything is done, completed. An occupancy can be permitted without all the safety requirements being taken. They're noted as a deficiency. The final inspection completes all that. In regards to the inspection or the inspector going out and checking it, I can probably well assure you that in a new subdivision, a building inspector will note any new decks and will look to see if there is a permit that has been issued or not. I don't think it's a case of creeping or being unfair. They're just ensuring that everything is being done. And as we've heard in this particular subdivision, the lot coverage is an issue because of the drainage and the size of the lots. So that's my only comment, and I'll ask the applicant, or is that our chief planner on the line there? Do you wish to say something, sir?
I have nothing to say besides the deck. We put in a floating deck in the conversations that we had, but I trust that you guys are making what is best for the community.
Thank you. Brent, do you wish to comment?
Thank you, Mr. Chair. Really, I was going to chime in to basically say exactly what you had said, is that those types of inspections final inspections usually take a look at final things that need to be completed on the house in order to close out a file. So really, I was going to say exactly what you had reiterated, exactly what you had said about the process with respect to the chief for the building permits and the building inspectors.
Thank you. Mr. Webster?
Can I assume then that the inspection was based on the municipality assuming the subdivision at that time?
Go ahead.
Through you, Mr. Gannon, to member Webster. Assumption of a subdivision and the, I guess, final inspection of a dwelling are two different processes. The final assumption of a subdivision really relates to the confirmation that all of the roads, all of the utilities, all the services are absent of any deficiencies before the municipality takes it over. The final inspection on a dwelling is to make sure that there is no other deficiencies from a building codes perspective that need to be corrected.
Thank you. Mr. Webster?
Another question for you, Mr. Henry. Were you given the option of reducing the size of your deck and avoiding this $1,100 application?
I was not given that option, but I would not be interested if possible to do that, but I was not given it based on the way that we had designed it and where the footings were.
Okay, so you're satisfied with the outcome, even though we had the cart in front of the horse at the municipal level?
The best way to answer that is obviously I would have preferred to have not paid $1,000 for it had I have known, and also I would have preferred to pay the double the permit fee, which I will be paying because I didn't apply for a permit in advance. But that being said, to keep my deck, I am okay with what's going to happen.
Okay, thank you.
Thank you. Were there any members of the public who wish to make comment on this?
Thank you, Chair. There are no members of the public which registered to make an oral submission.
Thank you. I have a motion here. Does anybody wish to move and second it? Henry, are you moving it? Anybody seconding it? Patty? Thank you. Committee of Adjustment, file number A05/20, dated August 26, 2020, applicant L and J Hendry, moved by Henry Vanderwill and seconded by Patty Kennedy, that the Committee of Adjustment, having given consideration to the applicable provisions of Section 45 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the land in question and its surroundings as addressed in the planning report on the application dated August 26, 2020, correspondence received and information presented at the hearing held on August 26, 2020, and the discussion on the matter, hereby approve application A05/20 as applied for. All in favor? Unanimous, carried. Thank you. And when the secretary is ready.
So we have minor variance application A0620 by M. Henry, owner of lands municipally known as 31 Laddie Lane. The purpose and effect of the application is to permit the construction of a detached garage measuring 66.89 square meters or 720 square feet with a height of 5.2 meters, which will result in an increased maximum total area and height of detached accessory buildings or structures on the property. A maximum total area of accessory buildings or structures of 130.06 square meters is being proposed, whereas the zoning bylaw permits a maximum of 65 square meters and a maximum height of 5.2 meters, where a maximum height of 4.5 meters is permitted under the zoning bylaw.
Thank you. Is there any additional correspondence or comments that have been received?
We have received additional correspondence on the file. We received comments from the chief building official stating that the septic may project more towards the west property line. However, there should remain an adequate clearance to allow vehicle traffic from impacting the septic distribution pipe. It, however, be highly recommended that clearly visible demarcation buffers be utilized by the property owner to prevent accidental compaction of the septic distribution pipe via the access driveway for the proposed garage. No other concerns. And then we received a letter that was provided to the committee members from an agent of the property owner at 1256 Wilson Drive, having some concerns about the visual impact of the proposed structure to that property.
Thank you. May I please have the applicant and/or their agent introduce themselves and present the application.
Hi, good evening. It's Mike and Vanessa Henry. We are the landowners of 31 Laddie Lane, and we intend to build a detached garage on the southwest corner of our lot. As collector car owners that support local car club activities, we require additional indoor parking space to accommodate our collection of classic vehicles. And just to add to that, my lovely wife, Vanessa, would like to park inside our garage that's attached to the house. Therefore, another reason for us to submit the variance here. Details of the detached garage, including site plan, as well as a copy of the stamped drawings, were included as part of a minor variance as submitted on June 2nd. We will fully comply with all Springwater Township regulations as we did back in 2018 when we constructed our wonderful pool cabana. Speaking to the chief building official, the septic clearance is definitely adequate, and clear demarcation buffers are in place. There is a rock wall on the southern side of the septic bed, as well as a 6x6 fence that is demarking the closest proximity to the driveway. As for the visual impact concern, that has been rectified with the landowners next door, and I've been speaking with the municipality on moving my setback from the original 1.5 meters to 3 meters, as well as complying with some vegetation, small cedar tree plantation.
Thank you. Are there any members of the public registered to make any oral submissions relating to this proposal?
No members of the public were registered to make an oral submissions.
Thank you. Members of the committee, any questions? Mr. Webster.
Thank you, Chair Gannon. I'd just like to point out that in the letter from MHBC Consulting, there's a note that says, refers to a planning initiative that does not exist. So there is no plan on the property adjacent to this. And I think that when we receive these letters, if there is a planning initiative, we as a committee should probably be notified if there's a planning initiative. There is no planning initiative that I'm aware of. And they also make a comment that this garage is going to be in the front beside. But since there's no planning initiative, there's no reason to take that position. It's a comment that planners make that planners shouldn't make. Thank you.
Thank you, Mr. Webster, and I was going to also suggest that I wasn't aware of any plan of subdivision going in that property. Property had only been sold this past spring, as I understand, so I'm interested in that. And just a quick question to staff before any other members. Is the 3 meter already shown on the plan? I wasn't aware of that. 3 meter setback? No, he's indicating now that it's going to be a 3 meter.
Thank you, Member Again, absolutely. It's on the plan that's in the staff report. It's 1.5 meters, which staff are okay with. In speaking with the applicant today, I understand that they are willing to work with the comments received today and are willing to move that to 3 meters to sort of alleviate any issues.
Thank you. Any other members of the committee have any questions? No, I have a motion here then. Does anybody want to move and second it? Moved by Patty, seconded by Mr. Cooney. File number A 06/20 dated August 26, 2020. Applicant is M. Henry. Moved by Patty Kennedy, seconded by Lauren Cooney. That the Committee of Adjustment, having given consideration to the applicable provisions of Section 45 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the land in question and its surroundings as addressed in the planning report on the application dated August 26, 2020, correspondence received and information presented at the hearing held on August 26, 2020, and the discussion of the matter, hereby approve application A06, 2020 as applied for. All in favor? Carried unanimously. Thank you. And when the secretary is ready,
Okay, minor variance application A0720 by C. Sheehan, owners of land known municipally as 1 Woods Drive. The purpose and effect of the application is to permit the construction of a 52.03 square meter addition onto the existing accessory structure, 127.03 square meters in size, which will exceed the maximum total area of accessory buildings and structures permitted on the subject property. A maximum total area of accessory buildings and structures of 189.92 square meters is being proposed, whereas the zoning bylaw permits a maximum of 115 square meters.
thank you. Is there any additional correspondence or comments?
We received comments from the chief building official stating that building has reviewed the application and do not have any objection to A07. They note that a building permit application has not been submitted for the garage addition, and more extensive review in relation to the building code will be undertaken at that time.
Thank you. I would ask the applicant or their agent to introduce themselves and present their application, please.
Hi, how are you this evening? Thank you. My name's Cliff Sheehan, 1 Woods Drive. The reason for this request is originally we have a shop and we wanted we're going to put a lean-to up, but we didn't feel that it would look right, and we decided as we looked at the area beside our existing shop that it would be much more cosmetically appealing to put an addition on to the shop, and that's to store my lawn tractors and things like that, and that's why I'm applying. Thank you.
Thank you. Are there any members of the public registered to make any oral submission relating to this proposal?
There are no members of the public which registered to make an oral submission.
Thank you. Any members of the committee? Mr. Vanderwillen.
Through you, Mr. Chair, to the applicant. So you're making the building longer, so coming more towards the road then, is that correct?
Yes, it's 14 feet wider, and the length is actually the length is not approaching the road, the width is by 14. There's plenty of room. There's quite a bit of land on that side, and it's not, I don't have any neighbors that are actually on that side. It would be the opposite side of South North Road.
So is the building being extended further north, south, east, or west?
I guess it would be mainly north, that side of the shop, yeah.
Okay.
I did submit a plan of it.
Yeah, I personally don't have any diagram showing the proposed building. That's why I asked the question.
Okay. It's mainly north towards the South Shore Lake Road. And it's not like when we're done, it won't even look any different than it is because it's going to be basically the same color blended to what we have now.
Thank you.
Member Kennedy?
Thank you. Thank you, Mr. Chair. Just a question for staff and perhaps the applicant. Is there a gas easement along the north boundary between South Ore Lake Road and your property?
It's quite a ways over towards the road, and it's at the front of Woods Drive is where all their meters are and things, which is basically at the very front of my property, and the shop is almost at the back of the property.
So my question is whether or not you know that if there is an easement along the north right-of-way of South Ore Lake Road, and whether or not that gas easement may have any impact on your setback for your building.
It's quite a ways from there. Just looking at the survey, excuse me, sorry. It looks to me like it would be minimum 20 meters away. I'm not an expert.
Mr. Sheehan, you're saying the gas easement is 20 meters away, or the edge of your addition will be 20
The edge
meters
of my
away?
property, the edge of my property.
For the gas easement or for the new build, for the addition?
Well, I don't see on my survey that there's an easement on it, because the property, I believe the easement is beyond my property line. And I mean, I don't see it on my survey.
Thank you. I'll just ask staff, was Enbridge or any other utility notified of this and whether they made any comments?
Just one moment, we'll double check.
When I was originally applying, may I talk?
Do you want to ask planner this?
I'm sorry, I didn't quite hear you. We have the planner on.
Through you, Mr. Chair, to answer that question, I can look back through the circulations. I don't believe we usually circulate utility companies unless there is a need to. But I will say that through the building permit submission, should anything like that come up, then the applicant will need to comply with that, obviously, and get all of the utilities marked as required for a building permit. That's all I can really comment right now. I'm not aware of an easement there just by looking at the site plan submitted by the applicant. But like I said, should something come up through the building permit submission, then this will be looked at. Just to make another comment, the proposed detached garage, there is a site plan that was attached to the report that should be part of your agenda package for this application. Now, the existing detached garage is to the rear of the property, and the addition is going towards South Ore Lake Road, but the setbacks are very great to the South Ore Lake Road as well as the rear property line, and it is substantially set back from the road. Should there be an easement or a gas line at the front of the property, like I said, it's set back quite a ways. I can do a measurement on my computer right here. But it will be looked at through a building permit submission. Thank you.
Thank you. Member Kennedy? Oh, Member Kennedy, can you just hang on for a second while the secretary says something?
I would just like to confirm that Enbridge was circulated and did not provide comment.
Thank you. Member Kennedy, anything?
Thank you, Mr. Chair. Through you to the applicant, I raise this because as staff is acknowledging, through the building permit stage, if there is an issue, it would be addressed then. However, if there's an issue and you have already paid and received this this variance, and you can't build as far out as you're anticipating, I'm just raising this. You may want to contact Enbridge and ensure that there's not an easement through there and there is not a specific setback requirement to any extension to that building before you move forward. Thank you.
Thank you. Did you wish to say something, Mr. Sheehan?
I just wanted to mention, I understand that. And I'm comfortable with that.
Thank you. And another question to staff. Generally, we receive something from the county of Simcoe when it's adjacent to a county road. Nothing from the county this time?
No, we received nothing from the county of Simcoe.
Thank you. And it was circulated to the county? Waiting for the planner to come back on?
No, Lauren will be able to check for us.
Thank you.
Sorry,
Mr. Cooney's first here, go ahead.
Also, in that regard, through the chair to staff, was the Conservation Authority circulated on all of these applications? Because there seems to be no comments at all from them.
I do have a letter from them. Oh, I'm sorry.
I can confirm that this application was circulated to the Conservation Authority as it is regulated. The applications that were not regulated were not circulated at their request.
Thank you. Mr. Webster?
Thank you, Chair Gannon. The survey, which was done February 25th, 2020, so it's recent, registered easements and/or rights-of-ways, none listed in the parcel registration.
Thank you. And the planner was on and disappeared. We're done? No other comments? Did you determine?
Lauren's doing
No, I have no further comments unless you have more questions for me.
No, I'm good. Mr. Webster?
I'd just like to make sure we get our numbers, that the approved motion doesn't reflect the numbers in the report. It speaks to a 9,113.23 square foot pool house. I think a 9,000 square foot pool house would be a beauty.
Yeah, that would be quite the pull.
It's on page 3 at the top.
That'd be one
So-
nice pool
Sorry
house.
about it. I just read it and I go, oh.
I believe you're referring to in the report, not the decision that you'll be signing tonight. I noticed that there is a typo in the pool house. I believe it should be 91 square meters, or square feet, sorry.
Sorry, I apologize for being like that.
No need to apologize for pointing out what could cause problems in the future. Any other comments from members of the committee? I have a motion here. Who wishes to move it and second it? Moved by Lauren Cooney, seconded by Henry Vander Willen. Committee of Adjustment, file number A07/20 dated August of 26, 2020, applicant C. Sheehan. Moved by Lauren Cooney, seconded by Henry Vander Willen. That the Committee of Adjustment, having given consideration to the applicable provisions of Section 45 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the land in question and its surrounding as addressed in the planning report on the application dated August 26, 2020, correspondence received and information presented at the hearing held on August 26, 2020, and the discussion on the matter hereby approve application A0720 as applied for. All in favor? Carried unanimously. Thank you.
Thank you.
Ask the secretary to introduce the next application, please.
Minor variance application A0820 by M. Howe, owner of lands known municipally as 2325 Old Second South. The purpose and effect of this application is to permit the construction of a 668.9 square meter industrial storage building for the for a contractor's yard with a reduced rear yard setback of 3 meters and a decrease in the required parking spaces on the subject property. A minimum rear yard setback of 3 meters is being proposed, whereas the zoning bylaw permits a minimum of 10 meters. A total of 9 parking spaces are proposed, whereas the requirement is 22 parking spaces, calculated at the rate of 1 space for every 40 square meters of gross floor area.
Thank you. Is there any additional correspondence or comments that have been received?
We received comments from the risk management official dated August 7th, 2020, stating no storm SWP comments or screening form is necessary as the property does not fall within a vulnerable area.
And can you advise us what a risk management official is, please?
They speak to source water protection.
Thank you. Go ahead.
Just to clarify that, yes, so they're, under the Clean Water Act, they're required to assess commercial, industrial within wellhead areas or intake areas for water for the municipalities.
Thank you. I ask the applicant to introduce themselves and explain their proposal.
Hello, this is Sherry Lynn from Springwater Engineering. I'm speaking on behalf of my client, Michael Howe. My client, Michael, is proposing a 668.9 meter squared, single-story industrial storage building. The building will store a disinfectant product for the sterilization of buildings due to COVID-19. And some vehicles will be stored also when they're not in use. The property has an existing residence and a building that is being used as a place of business, and the proposed building will not be occupied on a daily basis. We're asking for relief from the required 10-meter rear yard setback to 3 meters. There's a row of mature trees dating back to the 1930s that would have to be removed if the 10-meter setback was met. Our client wishes to maintain these trees and use them as a shroud to block the building view from the road. Our second item is a reduction in the required parking. The building requires 22 parking spots, and we are asking for a reduction to 9 parking spots, along with maintaining the 2 existing residential spots. The business will only have 4 people working at any given time, and the additional parking is not required for the business operations. Thank you for your consideration.
Thank you. Are there any members of the public registered to make any oral submission relating to the proposal?
Thank you, Chair. There are no members of the public which registered to make an oral submission.
Thank you. Any committee members wishing to ask any questions or make comments? Mr. Webster.
Thank you, Chair Gannon. I wonder if somebody could help me with page 4. I'm not quite sure what this means. Of the reduced parking will provide for the necessary parking required for the proposed contractor's yard. I read that several times and I still don't think I understand.
I would direct it to Planner List.
Go ahead.
Through you, Mr. Chair, to Member Webster. I believe just rereading that sentence in my report, what I'm referring to is that the proposed contractor's yard under the zoning bylaw does not have a minimum parking standard. So what happens is we default to other industrial uses, which requires a larger parking standard as 22 spaces, I believe the calculation was. The proposed business only requires a few employees, and I think that would be similar to other contractors' yards. And that's what that sentence means. The proposed use doesn't require those 22 spaces and would be.
Go ahead, Mr. Webster.
May I recommend that planning make a note that on the next official plan amendment process that be sorted out? I think it would be appropriate to have designated parking for a contractor's yard. It seems that may have perhaps been overlooked.
Thank you. Any other members of the committee with any questions? Seeing none, I have a motion here. Does anybody wish to move it? Moved by Henry Vander Wielen, seconded by Mr. Webster. Committee of Adjustment, file number A08/20 dated August 26, 2020. Applicant is M. Howe. Moved by Henry Vander Wielen, seconded by Rick Webster. That the Committee of Adjustment, having given consideration to the applicable provisions of Section 45 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the land in question and its surroundings as addressed in the planning report on the application dated August 26, 2020, the correspondence received and information presented at the hearing held on August 26, 2020, and the discussion on the matter hereby approve application A0820 as applied for, subject to the following condition: that the applicant apply for and receive site plan approval for the proposed industrial storage building for a contractor's yard. All in favor? Unanimous, carried. Thank you. When the secretary is ready.
So we have consent application B02/20 by Celeste Phillips of Celeste Phillips Planning, Inc. On behalf of the property owners, known municipally as 3281 Ushers Road and 1568 County Road 92. The purpose of the application is to obtain approval to sever a residential parcel of land containing an existing dwelling and consisting of approximately 1 hectare of lot area and 114.5 meters of frontage along Ushers Road. The applicant proposes to retain the commercial parcel consisting of approximately 6.35 hectares with 168.1 meters of frontage along County Road 92.
Thank you. Any additional correspondence or comments that have been received?
We did receive comments from Hydro One dated August 7th stating they have no comments or concerns at this time. We have comments from the drainage superintendent stating that the property is not assessed into a municipal drain and the condition is not applicable. The chief building official provided comments on August 26th stating that in review of the health unit records for the location of the septic system, the existing sewage works appear to be fully contained within the respected severed and retained portion. Thus, no objection to this regard. A drilled well is located on the property, on the proposed retained lands, and it is their understanding that the applicant plans on providing a new well to service the existing dwelling on the severed portion. As such, no objection to this application, provided a new well located on the severed portion is provided to service the existing dwelling on the same severed portion.
Thank you. May I have the applicant or their agent introduce themselves and make their presentation, please?
Good evening, Mr. Chairman and members of committee and township staff. My name is Celeste Phillips. I am a land use planning consultant, and I'm speaking to you this evening on behalf of Frank Bates. The family owns the Elmville Flea Market property. Lauren has been kind enough, I believe, to provide you with a very brief presentation material that I'll just go over quite quickly with you this evening, and hopefully that's been circulated to you on desk. So yes, the request is for the severance of the existing single detached dwelling from the balance of the lands so that Mr. Bates can retire in that house that is on Ushers Road. So yes, there's 2 addresses. You'll see those on the location map in the PowerPoint illustrations. 3281 Ushers Road and 1568 County Road 92. It's an L-shaped property. It's about 7.3 hectares in size, and it's been in the same ownership for almost 30 years. About 3.3 hectares is used for the actual flea market. The request this evening is to sever off that house that fronts onto Ushers Road with a lot size of 1 hectare. Turning to the slide with the existing use of the property, as I mentioned, there are 2 distinct uses here. The house was constructed in 1998, but the flea market itself has been in operation since 1960, so for over 60 years. Turning to the slide with the current zoning listed on the top right corner, because these lands are designated agricultural in the county official plan, there was the need to pre-consult with the county and the township, and my clients actually retained an agronomist to assist them with this property. So the property is designated agricultural in the county official plan, but it is actually designated highway commercial in the Springwater official plan, and it's zoned rural commercial. So it's a bit of a complication there with the designation and zoning of the property. In the end, the county agreed that the severance will not fragment agricultural lands. There are guidelines from the Ontario Ministry of Agriculture and Food that state when an agricultural impact assessment is required, and the determination was that one is not required in this instance. As you know, members of the committee, the provincial policy statement generally discourages severances, but there are exceptions for agriculturally related uses. And as a result of pre-consultation with the county and the township, a determination was made that there would be support from planning staff at both the township and the county for this severance. provided the residential lot was limited to a maximum size of 1 hectare. So the final slide shows the proposed severance line. Each lot would have its own well and septic, and as mentioned, there is really only the one well at this point on the flea market lands. So there will be the need to drill a new well for the severed lot if the committee is inclined to grant the request this evening. And staff at both the county and township planning level have requested that the house lot be rezoned to restrict it only to residential uses so that no commercial activity can take place on that land. And then as a corollary to that, the flea market lot would be rezoned to prohibit residential uses on those lands. So the owner wishes to divest himself of the flea market use, but remain as a retiree in the single-family dwelling on Ushers Road. So it's my submission to you that this does represent good planning. It does conform to the provincial policy statement and the county and township official plan, and I would request your approval this evening. Thank you.
Thank you. Are there any public comments?
There are no members of the public which registered to make an oral submission.
Thank you. Any members of the committee have any questions or comments? Member Kennedy, go ahead.
Thank you, Mr. Chair. Through you to the applicant's representative. Celeste, I noticed when I was out there that the driveway to the residential unit also acts as a exit from the flea market. And I just wondered if you could clarify whether that exit, whether the driveway and exit will remain in place as it's being used today, or if it will be separate driveway entrance for the residential use only, and the exit from the flea market will be terminated.
Oh, good question, Member Kennedy. Yes, there are probably what you saw as the orange pylons on the driveway. So there is to be no interaction between the Elmvale Flea Market and the house. So the house will keep its own existing driveway, and it's 1 hectare lot as proposed. And then access to the flea market will be only access and egress to the flea market will only be from 92.
Thank you.
Member Cooney?
Hi Celeste, Lauren here, through the
Lauren.
chair. Just wanted to, there are a couple of storage containers on the proposed residential lot. I assume those will be removed and relocated to the, I guess, the commercial area?
I'm actually not sure about that, Member Cooney. I can certainly check with the owner. Certainly everything associated with the flea market should be, in my opinion, on the flea market property, and the residential use should remain as a residential property.
Okay, thank you. I just was wondering, with a question now for staff in that regard, if those storage containers are considered coverage.
Mr. Cooney, just before you get an answer to that, my client's just texting me to say that the storage containers will be removed from the residential property.
Thank you, Celeste. And I have a question for staff with regards to the rezoning that possibly will come forward. Or will there be provision in the approval of the rezoning for visual screening between the commercial use and the residential use?
Member Cooney, at this time, given that the rear of this residential property is essentially a farm field or vacant farmland, at this time I'm not requesting any visual buffers to be as a requirement for that residential lot.
The reason I ask is that there could be expansion of the flea market where they could move their parking into that area, and being located right behind the residential property, it could become a nuisance in the future.
Through you, Mr. Chairman, as part of that, I would expect a site plan amendment application or site plan application for the commercial lands, and through that, we would be seeking some form of buffering for any residential expansions of the commercial.
Okay, thank you.
Any other members of committee have any questions? I have a motion here. Make sure I got the right one. Okay. Do I have Lauren? Second by Patty. Okay, big long one here. Committee of Adjustment, August 26, 2020, moved by Lauren Cooney. My apologies, seconded by Patty Kennedy. File number B02/20, applicant F.D. Bates. In the matter of consent application B0220 for lands known municipally as 3281 Ushers Road and 1568 County Road 92, and legally described as Lot 10 Concession 9, former Floss, now in the Township of Springwater, roll number 43410300061170. That the Committee of Adjustment, having given consideration to the applicable provisions of Section 53 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the subject land and its surroundings as addressed in the planning report on the subject application dated August 26, 2020, correspondence received and information presented at the hearing held on August 26, 2020, and the discussion on the matter, hereby approve the application as applied for, subject to the following conditions. Number one, that the applicant meet all requirements, financial and otherwise, of the municipality. Number two, that the applicant provide 2 copies of the registered survey of the severed lot prepared by an Ontario land surveyor. Number 3, that the owner applicant satisfy and be responsible for all costs to satisfy Section 65 of the Drainage Act 1990, if applicable. Number 4, that the applicant rezone the severed residential lands to a site-specific zone in order to restrict permitted use to residential. Number 5, that the applicant rezone the retained flea market lands to a rural commercial exception, CR-XY zone to prohibit further residential uses from being constructed. And number 6, that it be confirmed that a private well and septic system are wholly contained within the property limits of both the severed residential land and the retained commercial lands prior to the registration of the severance. Note, if all conditions of this decision have been fulfilled within 1 year from the date this notice of decision is mailed, and all authorities have been so notified, the committee in writing, the Secretary Treasurer is authorized to provide a certificate as provided for in subsection 53, paragraph 42 of the Planning Act, RSO 1990, CP 13. All in favor? Carried unanimously. Thank you.
Mr. Chairman, may I just add one comment?
Go ahead.
I believe that what was read out to you, and I just wanted to verify that the condition number 3, I think what was read out earlier as part of the correspondence, that matter associated with the Drainage Act is not applicable here, and I just want a clarification on that.
We understand that that is correct from planning staff.
Thank you, and congratulations on a successful first virtual meeting. Good night.
We're working at it. Thank you.
Thank you.
Okay, and the last item on, or the last application on our agenda this evening.
Okay, so we have consent application, do we have to?
I'm going to ask, do we have to ask the members to remove themselves from the room, or can they just stay away from their desks?
Yeah, and just not participate in discussion is fine.
Thank you.
Good. So consent application B0320 by N. Langiel, sorry if I said that wrong, owner of lands known municipally as 45 Huron Street. The purpose of the application is to obtain approval to sever one new residential lot consisting of approximately 1,092.39 square meters with a frontage of 30.48 meters on Stokes Drive. The applicant proposes to retain approximately 1,092.54 square meters of lot area with approximately 30.96 meters of frontage on Stokes Drive, containing a single detached dwelling.
Thank you. And I understand there is a number of comments here.
Yes. So we received comments from Hydro One dated August 7th, 2020 that stated they have no comments or concerns at this time. We have comments from a resident of 2 Stokes Drive. It's my understanding that the committee members have copies of all these comments, so I will just provide a summary. They have comments regarding the negative impact to the community plan due to lot size, opening it for further development by subdividing individual lots. Water restrictions are already placed in the community. Further development may impact the existing water resources and potential increase of traffic flow in the area. We received comments from Ainley's, which is the township's engineering consultant, regarding the water supply. In summary, they're operating at approximately 32% of the rated capacity. In their 20-year design plan, it's looking at just over 36%. On that basis, there appears to be enough capacity in the system. However, they would like to note that the existing water main is on the North Boulevard of Stokes Drive, and as such, the proponent will be required to extend a service lateral across the road to connect to municipal supply. It will likely be required that this will be completed by the township's preferred contractor at the cost of the proponent. It also provides a mention to watering restrictions and notes that we may wish to confirm with Public Works, which we have comments from them as well. So Public Works comments dated August 25th agreed, stating that the watering restrictions are township-wide, similar to other municipalities, allows people to water on odd or even days depending on street number. We have comments from the chief building official. They request 2 conditions, the first being that the applicant provide confirmation that the existing or replaced septic system is wholly contained within the boundaries of the retained lands, and that the applicant provide confirmation that the proposed lot can accommodate a private septic system. These would both be to the satisfaction of the chief building official. Also suggest that either a reasonable use guideline D54, individual on-site sewage system water quality impact risk assessment, be considered, or alternatively the new sewage system incorporate a level 4 treatment and nidification technology. The drainage superintendent provided comment that 45 Huron Street is assessed into the Swaley drain, and a drainage agreement will be required. A resident of 5 Stokes Drive provided comments dated August 25th. The commenter stated that they have lived at the neighboring property of 5 Stokes Drive since 1993, severing the adjoining lot so that another home can somehow be sandwiched onto Stokes Drive between my home is frankly astonishing, they stated. The location will lower the property value and will be of that of a city very sized lot crammed in into the existing subdivision. And then we also received comments from a resident at 10 Foyston Gate. We provided a copy of the complete letter. They had concerns about the lot size, given the size of other lots in the area and the official plan policy surrounding lot size. They also noted the proposed septic system, that the requirements that the chief building official has requested do not go far enough in terms of understanding the potential impact of this type of intensification. So, in regards for a private septic system may not have impact, potential accumulative impact, regards for a potential accumulative impact of multiple similar applications. And then they go on to discuss the growth plan and some concerns that they have with intensification / infill. So that's in front of you. And then we also just received comments from a resident at 40 Huron Street. They stated that they would like to be emailed details of the meeting, and if any other meetings take place, they would like to be notified.
Thank you. May I have the applicant or their agent provide their presentation, please?
Yes, good evening, everyone. My name is Norbert Landell, resident at 45 Huron Street. The purpose of the application is to obtain approval to sever one residential lot municipally known as 45 Huron. Our intention is to develop a new residential dwelling on the newly proposed property for my family and I. Really want to thank you guys a lot for considering this, and thanks again.
Thank you. Members of committee. Mr. Webster, go ahead.
Thank you, Chair Gannon. This, I guess I have some questions for planning. Based on the letter received from Brian McDonald, and there's some statements here that I'd just like to confer with you to see if I'm reading and interpreting them correctly. He speaks to lots being 40 to 110% smaller than the existing surrounding lot that was created under Plan 51 R490. Was anybody, are we able to determine if the existing dwelling was created under that plan?
I can confirm that the property is lot, I believe it's lot 13 on that plan that is mentioned. 51490, is that correct? The legal description. Yeah, it's lot 13, I believe. It is on that plan. Heatherwood Heights, I believe it is, phase 2.
Thank you. Now, so the statement that is being made here that the lot being applied for severance, then, I mean, clearly that's not true because the lot beside it is not 40 to 110% smaller.
Chief Planner, would you like to comment on this?
Thank you, Mr. Chair. Through you to Member Webster. I think, in general terms, I think I could agree with Committee Member Webster in that the percentage may be off in certain cases, and in order for staff to verify that, there would have to be a review of all the lots to try to determine to that degree of certainty.
May I continue?
Go ahead.
I mean, obviously, there's lots being created right now in the minor secondary plan that are not that size, so I'm not sure how that bylaw is of any relevance these days.
Go ahead.
Through you, Mr. Chair, to Committee Member Webster. You are correct in that lots created today are probably smaller than the lot being proposed right now, at least from a frontage perspective, because in normal circumstances, those lots are serviced through municipal water and sanitary. However, the zoning does have to reflect the servicing scheme that is being utilized for those individual lots, but I would say that this lot is larger than the lots that are being created in the urban areas.
And for clarification, this lot accommodates, because we have information to the contrary, this lot does accommodate the current style, if you will, of today's septic system.
Go ahead.
Through you, Mr. Chair, to Committee Member Webster, the way the conditions are worded and the suggested conditions by the chief building official would ensure that the septic would have to be fitted to accommodate a lot of this size.
Which, given today's technology, can be accommodated.
I would agree with that. That is correct.
Thank you.
Any comments or questions, Mr. Van der Willen?
Yeah, just, and I know it's, they have to get for the septic approval, and I don't know how the new ones work as the old ones, but I do know that the area there is heavy clay. There is very little water filtration coming off IE buildings, or and the same as for septics to work. But I get it, you'll have to dig the dirt out and put in sand or whatever is required to make that system work. But the other concern is like, when this subdivision was put up, it was, the lot sizes were for that reason. And then also to do with water runoff. The more roof we put up on there, there's going to be more water running downhill. So, and when it's required that it be 1,390 square meters, and the proposal is 1,092, being where it's situated, I have a concern with doing that, making it those lots smaller on that subdivision. That's all.
Thank you. Question for staff. There's indication here that this is part of the Swaley Drain. Is this going to be able to be a new residential or premises being constructed there, going to be able to be accommodated through that drain?
The comments from the drainage superintendent state that the property is assessed into the municipal drain. As part of that, they will have to enter into an agreement that if any maintenance to the drain occurs, they will have to pay their share on their property taxes to help with the maintenance of the Swaley Drain. So it's a levy that they charge when that occurs.
Okay, thank you. I think I have a concern too, because that is Henry has indicated, that premise of that property, that subdivision was built within estate-style lots and larger lots, and you know that is full of clay. We are very well aware of that. While the older part of the subdivision or the older part of the community is smaller lots, those are all large lots that are nice in size, and even the area further to the east has larger lots as well. I think my comment or my question is, if we allow one in this subdivision, in this area, are we opening Pandora's box and allowing others to do something similar? Of course, this is on a corner lot, so that does make it somewhat more challenging, but you know, are we in fact opening Pandora's box for others to come in and do, or ask to do something similar? And you know, is that in the best interest of the community and of the residents in that area, many of who've lived there for the 20 plus years that subdivision and that community has been there? I don't know if it's a question that staff can deliberately answer or answer. There's probably another 2 corners anyways that something else could occur on. And, you know, is that really intensification? Is that, perhaps that's my best question, is that really intensification that is desired in that community when everything else is large and isn't, you know, going to have that intensification? Perhaps staff can answer something to that, or make at least a comment to that.
Through you, Mr. Chair, I'll direct the comment or to Director Spagnol.
Thank you. Mr. Chair, I guess the first thing where I'd like to start is that the growth plan generally directs development and encourages intensification and infill within settlement areas where you've got existing villages, you've got existing development, you have existing services. The premise on this is that you already got the services there, so it's a more efficient use of land to allow for intensification in these situations. The question of whether or not, you know, a decision, and not to speak for the committee, but a decision of approval for this opens the door for future severances, really depends on each individual basis in each individual case. If somebody decides to apply for severance within this area to intensify on, say, for example, the corner lots. The provincial policy is pretty clear in that it is encouraging infill So the prospect of somebody coming in to apply is there regardless of an approval from this committee, because the basis for that encouragement within provincial policy is what's driving for intensification. So what I'm trying to say is that the committee's not bound by precedent. Each individual application is different. You may have other properties where they might not have adequate land area to come in at a lot size that's being considered here under this application. You may have other situations where the placement of the house might not allow for the consideration of such a severance. So in a nutshell, I think, you know, the committee's not bound by precedent, and the ability to apply and the right to apply is there for any property owner who has a lot, an oversized lot, where they may have additional lands where they could potentially get a severance. So I think the decision of the committee doesn't necessarily, and it doesn't bind the committee to future severances. But I think the key here is that the application process and the policy that's there allows for consideration of intensification in situations like this.
Thank you. Member Webster?
Thank you, Chair Gannon. I'm not fond of breaking. I was in this chair for 4 years, and we made laws, and I'm not fond of breaking laws. And if the municipal bylaw is in place at 1,390 square meters, we would be breaking that law. So I'll just make that comment, but then in addition to that, I'll say, I wonder what are the other resources available to the applicant? Can he take this to LPAT? I see your head. I see you saying yes.
Yes, Committee Member Webster, the applicant has the option to appeal the decision of the committee to LPAT.
Thank you.
Were there any other comments from the public registered to make any oral submissions on this?
There were no members of the public which registered to make an oral submission.
Thank you. Henry, any other questions or comments?
Yeah, just one question through you, Chair, to Mr. Spanigal. What's the smallest lot size then it's allowed now, like in the township then?
Mr. Chair, through you to Committee Member Van der Weylen. What I'm doing right now is I'm just flipping to the urban residential UR1 zone. So those would be the zone categories for the Midhurst secondary plan. And under an R1 zone, hang on a second here, sorry. What I can do is I can give an example from the Yorkwood subdivision known as Stone Manor Woods, which provides for somewhat larger lots. So under the UR1, oh, I found it now. So for Midhurst, under the UR1 zone, a lot of 134 square meters is permitted for a UR3. And under the UR1 zone provisions, it allows for a 446 square meter lot. So that's taking you from the smallest to essentially what would be considered to one of the largest lots under the urban residential UR1 zones.
Go ahead, Secretary.
Just to clarify, the UR1 permits a single detached dwelling, whereas the UR3, I think, allows for like a townhouse or a fourplex. Is that correct, Director Spagnol?
That is correct. And the UR2 zone also allows for a single detached dwelling at 290 square meters.
Mr. Webster.
Thank you, Chair. Again, I would point out, though, that's on both water and wastewater management. It's not merely water and septic.
That is correct. Committee Member Webster.
Okay, thank you. So we have an application. There's only 3 of us here, so I need one of you to move it, one of you to second it, and then we can decide whether we're approving or not approving.
I'll move it.
Thank you. Webster? Okay. So, file number B03/20, applicant N. Langell. In the matter of consent application B0320 for lands known municipally as 45 Huron Street and legally described as Lot 13 on Plan M 490, former Township of Vespra, now in the Township of Springwater, roll number 431-010-005-09922. That the Committee of Adjustment, having given consideration to the applicable provisions of Section 53 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the subject land and its surroundings as addressed in the planning report on the subject application dated August 26, 2020, correspondence received, and the information presented at the hearing held on August 26, 2020, and the discussion on the matter hereby either approve or deny the application. Which is your choice, gentlemen? Thank you. That the Committee of Adjustment, having given consideration to the applicable provisions of Section 53 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the land in question and its surroundings as addressed in the planning report on the application dated August 26, 2020, correspondence received and information presented at the hearing held on August 26, 2020, and the discussion on the matter, hereby deny the application as the proposed consent does not conform to the policies of the official plan of the Township of Springwater. Correct? And objections were received from residents. Correct? All those in favor? Carried. Thank you. Sorry, other business. Item 5.1, reissuance of notice decisions due to the state of emergency COVID-19. Does anyone from the committee wish to comment or have any questions related to this item? Seeing none, that the explanatory note from the Deputy Secretary Treasurer dated reissuance of March 12th, 2020, notices of decision dated August 26th, 2020 be received, and the Committee of Adjustment execute the revised notices of decision for each of the following applications: A0320 Webb, B2418 Lakelands Irrigation Limited Graham, and B01/201953-518 Ontario Limited /Woods. May I have a mover and a seconder? Moved by Mr. Cooney, seconded by Mr. Vanderwielen. All those in favor? Oh, I'm sorry, questions? Go ahead.
Mr. Chair, because I wasn't at that meeting, can I vote on that? Can
I think you can,
participate in it?
I think you can move in second, you won't sign the decision.
Okay, so, but I could be in favor of it? I'm just confused because I wasn't here for.
So you're just moving the motion that we execute the revised
Okay.
notices, so that's fine, and you can vote on that. You just won't sign the actual decision document.
Perfect. Thank you so much.
Thank you. All those in favor? Carried unanimously. Item 5.2, appointment of Secretary Treasurer. Does anyone from the committee wish to comment or have questions related to this matter? I'd don't know, Shania, do you have questions or comments? Are we worried? Should you be worried now that she's really seen us in action? That the Committee of Adjustment hereby appoint Shania Wanfor as Secretary Treasurer of the Committee of Adjustment. May I have a mover and seconder. Moved by Patty Kennedy, seconded by Lauren Cooney. All those in favor? Carried. Now the tough one. That the Committee of Adjustment meeting held on August 26, 2020 does now adjourn at 8:32. May I have a mover and a seconder. Henry? Patty? All those in favor? Carried. Thank you.